News broadcast tone. Harvard and the Trump administration are once again squaring off in federal court, this time over a presidential proclamation that bars many international students from entering the United States. Here's what's happening. Reportorial. In late August, the White House issued a surprise order suspending entry for certain visa holders, mostly graduate students and visiting researchers who, in the administration's view, could compete with the United States workers or pose a security risk. Somber. Almost overnight, some Harvard students with valid visas found themselves detained at airports, questioned for hours, and ultimately sent back home. Others were told not to. Harvard is now asking a federal judge in Boston for an emergency injunction, arguing the proclamation is illegal and must be put on hold while the case plays out. The university says the order upends academic programs, empathetic, strands students in other countries, and threatens research projects that rely on international talent. University lawyers point out that international students contribute an estimated $40 billion a year to the United States economy, and in many fields, help staff the labs that drive American innovation. This isn't the first clash between Harvard and the Trump administration. 3 years ago, when the Department of Homeland Security tried to force international students to leave the country if their classes moved online during the pandemic, Harvard and MIT sued and won. The new proclamation, Harvard argues, is a rerun with the same legal flaws. It was issued without public input, offers no clear evidence of economic harm, and, serious, exceeds the president's authority under immigration law. The Justice Department counters that protecting American jobs is well within the president's power, especially during an economic recovery. Government attorneys say the proclamation is narrowly tailored, temporary, and justified by national security concerns. They will likely point to Supreme Court rulings that give presidents broad discretion to control who can enter the country. For students, the stakes are immediate. Without court intervention, Harvard estimates dozens of its students will miss the start of the fall term. Some are working on time-sensitive medical research. Others are teaching assistants for large undergraduate courses. Many have already paid rent in Cambridge and left jobs or family commitments abroad. The uncertainty is also rippling across higher education. Universities from California to New York depend on foreign students for tuition revenue and as a pipeline to graduate programs. The judge hearing the case, Federal District Court Judge Allison Burroughs, is the same jurist who handled Harvard's 2020 lawsuit. She could decide as early as next week whether to grant the injunction. If she does, the policy would be paused nationwide until a full trial or a settlement resolves the underlying questions. If she denies the request, the restrictions stay in place and students will have to wait for an appeal. Beyond the courtroom, the fight underscores a broader debate about America's openness to global talent. United States universities host nearly 1 million international students, and surveys suggest many are now weighing offers from Canada, the UK, or Australia, where visa rules are perceived as more predictable. Business groups warn that if the United States appears unwelcoming, companies could follow the talent overseas. In the next few days, expect emotional testimony from students who spent the summer in limbo, data-heavy briefs from economists on both sides, and sharp questioning from Judge Burroughs about presidential power. Whatever he decides, history suggests the losing party will appeal quickly, meaning the legal saga could extend well into the academic year. For now, students and universities alike are refreshing their email, waiting to see whether the fall semester will begin in classrooms and laboratories in Cambridge or on computer screens thousands of miles away.